We're back with the Tech Policy Grind. I'm Rima Musa, and I'm a fellow with the Internet Law and Policy Foundry, the organization where the next generation of tech law and policy professionals convene to write, think, and talk about the web, technology, and disruptive innovation. This is the Tech Policy Grind, the Foundry's podcast where we chat about what's going on in the world of tech policy. Welcome back. Cybersecurity regulations have been on the rise lately. So this week, Class 5 Foundry Fellow Gabe Rudin sat down with Jena Valdetero, co-chair of Greenberg Traurig's U.S. Data Privacy and Cybersecurity Practice, to talk about how she got into Cyberlaw, instant response, and the new SEC cyber rules. Hope you enjoy.
With us today is Jena Valdetero, who is doing incredible work at GT, or Greenberg Traurig, and you are the co-chair of their Data Privacy and Cybersecurity group. I would love to know a little bit more about how you found your way into data privacy and cybersecurity law.
So it's a really exciting time to be an attorney in this space. 20 years ago, this wasn't an area of law. I mean, obviously we had HIPAA, we had the GLBA, but there was not really a specialty that was strictly privacy or security. And so it's not like when I went to law school, there were any classes. I mean, absolutely zero classes that you could take in this area. So I'm always fascinated when people are telling me about the awesome curriculum offerings that law schools now have in this space. I started out as a commercial litigator. So I was defending companies. I've always been in big law, and defending companies in class actions and consumer actions. And then I had a conversation with my now partner, David Zatuni, around 2011, 2012, where he said, I'm seeing more and more companies have people breaching their data. And it turns out there are some laws that say you've got to report this if it happens. And no one really knows how all this works and knows how to handle these types of incidents. So I'm the only one at the firm who's doing it, and it's ruining my nights and weekends. So do you want to learn and also have your nights and weekends ruined? At the time, I was very busy working on litigation. So, of course, I said yes, because I clearly have a pathological inability to say no. But it ended up being one of those conversations in life where you don't realize the significance at the time, but it is not an understatement to say it changed my life, because I started to shadow him. I got certified through the International Association of Privacy Professionals, the IAPP. At the time, they were still requiring the test to be in person. It was on a Scantron. So I was in Washington, D.C. with my flip cards. I made these little cards. I hadn't studied for a test in years at that point. So I got to nerd out a little bit. And then we had to wait like 8 weeks to get our results, which was a bit nerve-wracking. So I hadn't had that level of anxiety since I took the bar, although it wasn't quite, the stakes weren't quite as high, to be clear. And then, as things evolved, we started seeing more and more security incidents. It became a bigger part of my practice. Then 2016, GDPR, and the focus became, hey, now we actually care about privacy too. I always think about security and privacy as like fraternal twins. So they're actually quite different, but they go hand in hand. And so I started to learn privacy. Candidly, I read the GDPR cover to cover probably about 12 times. And then I would pick up the phone and call David and be like, I don't understand what this means. What does determining the purposes and means of processing actually mean in English? And so, from there, we started to see the movement with California, and then it's exploded.
So I just want to just real quick go through that proposition that you were given, which is, how would you like to have no nights and weekends? That's a fantastic way to introduce somebody to the field. But maybe we could get to, why is that the case? So, what is a breach? What context? What's the context where a breach happens, and what are the legal obligations that are triggered when a breach occurs? And are there different variables that impact what a breach is?
Yeah, so let's talk about the evolution of it, because when I first started doing this work, it was a lot of payment card breaches. And then with the advent of pen and chip, we saw those go way, way, way down. So then it became a lot of business email compromises. So we were dealing a lot with that. And then companies started deploying multi-factor authentication. It made business email compromises tougher, although we still see quite a bit, surprisingly. And we would occasionally see ransomware attacks. But I'm talking like 2016. So in those cases, we didn't ever see data exfiltration. It was all about encrypting the systems and then putting the company in a position where they had to pay for the decryption key, because otherwise you really couldn't operate. We had one where I swear the threat actor went on vacation in the middle of negotiations because he ghosted us for a solid week, and our client was freaking out because they were like, we can't do business. We literally can't operate. This guy's not responding to us. And then he finally reemerged with no explanation. But it was a very, very tense time. And then when COVID hit, we started seeing a shift really dramatically to remote work. And so I saw a lull in cases. And I remember saying to one of my partners, like, this is weird, right? Like, I feel like we should be getting calls constantly. And this was March, April. And what I didn't realize is the threat actors were just figuring out how to exploit people, because then May of 2020 hit, and then it was just an avalanche. And since then, what we've seen is a real focus on exfiltration of data. Companies have gotten smarter about backups and being able to restore from backups without paying for the decryption key. So now it's all about data theft.
Wow. So some of our audience consists of people who are familiar with the field. Some of the people may not be too familiar with those distinctions. Do you mind breaking down those definitions for us, like data exfiltration versus what's a ransomware attack? And how do you know if you're in one versus the other?
I think about it like a house. So if it's just a pure ransomware attack, no data exfil, that somebody got into my house but didn't really do anything except they put a padlock around it. So I cannot get into my house. I can't access anything. I can't do anything. And in order for me to get access to my house, I need to pay for the key. Now, this is where the analogy falls apart. But let's say I have a shadow house. So it's like my house, but like how my house looked 12 hours ago. So, I'm sure kids, sporting equipment everywhere or whatever. If I'm able to go and restore from that house, I don't need the key to my existing house. Maybe I've lost whatever we did in that house in the last 12 hours. So my shadow house is a backup, right? So when we think about companies, they back up their data. If you are able to say, hey, we're just going to pull the backup, it's clean, it's not been infected, it hasn't been encrypted, then we don't need that key. And so companies have started to get really smart about their backup strategy. A lot of times the backups are separate and apart from their live systems. So if you get your live system infected, you can't then, the threat actor can't then move laterally and get into that second house. It's just not possible. There's a fence, right? I mean, it's called air gapping. There's a separation. Data exfil is, now picture the threat actor has gone into my house and has rifled through my drawers and said, oh, here's her passport. Here's a bunch of financial information. I'm going to take some jewelry, whatever, and I'm going to steal it. And so I'm going to tell her, I will both give you the key to the house if I encrypted it, which is still happening. And I'm going to give you back your data that I stole. But if you don't pay me, I'm going to post all that data out there for anyone to steal. Or I'm going to sell it. And then, someone's going to use it for identity theft or some kind of nefarious purpose, maybe. And so now you have two decision points. Do I need it to operate? Yes or no? And increasingly companies don't, because they have good backup solutions and strategies in place. Do I need it to prevent potential posting of the data? And it becomes really challenging because the threat actors are going for data they know is going to cause you heartburn. So usually what they're doing is looking for unstructured data. So it's data that is saved on a local drive or a shared drive. So they don't even need to get into your crown jewels database, your key customer database or your employee database, because people work in a way that is convenient and fast. I'm no exception, and you save stuff locally if you're on an airplane or, you just need to get it out and you're having a problem with your database, crashing when you're trying to upload something. So you're just like, I'm just going to save it locally. And so they'll go and look for local folders like human resources, legal, et cetera, finance. And that's a set they steal because they know that that's information you'll care about. The problem is, even if you pay a threat actor to, quote, get your data back, which usually means they'll confirm they've deleted it. Sometimes they'll show a video of the computer screen where they're deleting the folders. They'll try to show some kind of proof. You never really have a full guarantee, right? You know who you're dealing with. Now everybody says, well, how can you trust them? I mean, you can't ever really trust them. But in terms of how are they going to continue to be effective at extorting companies, there has to be some indicia that they'll uphold their end of the bargain. And it's a small community. And if there's a group that is known for double crossing you, that group's not going to get paid. Like everyone in the industry who knows, who these threat actor groups are, will be all told about this. We'll all talk. And then if we have a client who's hit by it, we'll say, hey, we have some intel. That company, there was a company that paid them. And then a month later, they got double extorted or whatever. So it can be challenging. The other thing is, under the data breach notification laws, so each state has a law that says if sensitive personal information about residents of this state, and I'm generalizing, they define what that means, social security numbers, for example, if that has been subject to either unauthorized access or acquisition, you would have an obligation to notify those individuals, and in many states, depending, the state regulator, usually the attorney general. And so what are you getting by paying a threat actor? You really have to weigh this. You're getting the data not being posted, but you still have to tell people. You can't avoid that. And now increasingly, and this is really, we've seen a huge uptick in this since the California law, privacy law, was passed in 2020, which provides a statutory private right of action for damages for California residents if their information's breached, even if they don't have any actual harm. We've seen a huge increase in lawsuits. So class action lawsuits arising from data breaches. When you report to certain state regulators, certain states like Maine, for example, post it almost immediately. And they post a copy of your letter and information about the incident. And there are plaintiffs' lawyers who regularly check and then start looking for class reps.
And, I was thinking about what you were saying right there. There's been an uptick because of the law in private rights of action. Does that possibility or rather eventuality of a private right of action in some cases impact companies or victims rather decision on whether or not they're going to even pay the person who's been, the criminal, because they know they're going to get sued anyway. So why would I pay twice?
Right. And yeah, absolutely it does. We walk through this exact scenario with clients all the time where it's, you have to think about what are the consumer's expectations. It depends on who you are too, because, if you're B2B and you don't have any sensitive personal information, the information may not be that valuable. If you're B2C and you have sensitive personal information, those are your customers, right? And, you will have to potentially tell them, or they're going to figure out that this stuff was stolen from your system and you didn't pay and now it's out there. If you're B2B and you're hosting sensitive information of individuals that belongs to your business customers, that's a harder one. Those are actually the toughest ones because you're trying to address lots of competing interests. I think increasingly companies are deciding not to pay if it's just for exfiltration for the very reason you mentioned.
So I imagine in the way that I can see a breach happening, a client calls you on the worst day of their business career and says, we've identified an incident. Yeah. And we think it's scenario A or we think it's scenario B. They call you, you don't have the full story yet. What do you actually do? They've told you their data has been compromised in some unknown fashion. Who do you call? What's your next steps? Can you just walk me through what a data breach has looked like in some scenarios, depending on who your client is?
Absolutely. So let's take a ransomware incident because that's common. It's the one you kind of read about the most. So if we get the first call, my first question is, do you have insurance? So cyber insurance has become a big business. Companies were writing policies left and right, no real underwriting, years ago, because they weren't getting claims. And then again, when 2020 happened, we saw a huge shift. And now there are far fewer players in the space. They're writing much more expensive policies that don't have as robust coverage. There are more exclusions. But a lot of the cyber insurers will sometimes require you to use their pre-approved panel of vendors, which includes legal counsel. So we always have that conversation if GT is not on a panel. But the forensic investigators, generally the same kind of cohort of 10 are on everybody's panel. These are folks I work with all the time. Depending on the issue and depending on who I think might be available, I start messaging my friends at these places and say, hey, what's the soonest with ransomware attack? What's the soonest you can get a team together to get on a call so we can scope? And in general, we are able to get someone on a call with the client, a forensic investigator, within an hour of getting the call. I mean, almost always we can move pretty quickly and find someone. And so then the forensics guys ask questions. They need to get a sense of how many endpoints do you have, what's encrypted, what's, your system look like. And then they scope it out, get a quote, we get the contracting in place, and then they start working. So in some instances, we've been able to do this within a couple of hours. And so, their goal is generally to figure out what happened. So there's a difference between forensics, who are actually investigating the root cause, and then a company that's helping you restore and recover. So some of those companies do both. Sometimes they partner with another company who actually comes in and says, okay, we're going to, make sure your backups are clean. We're going to help you re-image these computers, whatever. If it's ransomware, there are companies out there. Sometimes it's the forensic investigators. Sometimes it's not, who actually their job is to negotiate with these guys. And those companies actually have great intel. So I've had many experiences where the vendor had better intel than law enforcement.
Wow.
Yeah, because you don't have to. Well, that's changing. But in general, if you get hit with a ransomware attack, you don't have to report it. And so a lot of companies don't. I mean, which is a shame. Law enforcement can be really helpful in telling you, here's what we're seeing with this group. If you're going to make a payment, you absolutely should report it because you could potentially run afoul of OFAC sanctions. So the Department of Treasury in the United States has said you can't pay, and this is agnostic of a particular event, like you can't provide material support or finance terrorism, nation state actors. So before you make any payment in connection with a ransomware attack or an extortion attack, you need to make sure that you don't have any reason to believe that this is someone who's on the OFAC list. And one of the things Treasury has said is, we'll look at whether you went to law enforcement to check that first and you told them you were going to make a payment. If it turns out you paid someone you shouldn't have, right? Were you trying to hide it? Were you being sneaky? Whatever. So before you make a payment, you've got to go do all of that. People always ask me, do you need a crypto wallet? Do I have to go as a company and open a wallet so we can buy $1 million in Bitcoin? No, there are vendors who will make that payment for you, which is extremely helpful. And sometimes depending on the type of company, we might bring in a PR expert. So we have folks we work with who are really good. And the reason you might need to do that right away is if the company is literally unable to do business and there's no hiding the fact that they've had an incident. Or I mentioned B2B incidents are expensive because you typically have an obligation under your contract with your business customers to notify them within, usually a short period of time, like 48, 72 hours. if there's been some breach of the system that, would affect them. So that's tricky because these things take time. So you have to go to your customers right away and say, hey, we've had this incident. There's really not much we can tell you. And I always say, keep it focused on how is this going to impact them, both operationally or, with data, and give them regular updates so that you don't have your B2B customers wondering what's going on. If people don't hear from you, they assume the worst. What are they hiding? What's happening? Is it a complete disaster over there? And so, doing regular updates, like usually twice a week in the beginning, I think is sufficient, is really helpful. And a PR firm can be really, really helpful in making sure everyone's getting a timely response and the responses are consistent.
Wow. So you're dealing with a bunch of different stakeholders, organizing a team and kind of shepherding this process. Yeah. Are you, as the attorney on the case, kind of the quarterback and letting them know these are your legal obligations, this is the realm of a business decision versus do not go afoul here because this is something that may come to bite you? And do clients do they tend to be looking towards individual vendors without consulting you at some point?
Sometimes. Yeah. So sometimes we get the call from a forensic investigator who says, hey, we got a call directly from this client and we've explained to them they need to bring in counsel. And the reason for that is all the things you mentioned, but also privilege. So the way it is done in the industry and the best practice is counsel hires these vendors because counsel I can't give legal advice based on what the company is telling me. I need to know what an expert says happened. Because whether or not we see evidence that a threat actor took data or looked at something or did something is not something I know. It's not within my knowledge because I'm not a forensic expert. So I need someone to give me that information so then I can say to the client, okay, now we have triggered, like the SEC just finalized their rules for public companies, which requires notification within 4 days or business days of determining a material event occurred, which is now specific to cyber events, which is a very hard trigger to meet. I can't make that determination without relying on a forensic investigator telling me, like, yes, this is what we found today, and me interpreting that legally and saying, all right, time to get that 8-Crave ready to file and move forward. There are other, I should just be clear, there are other regulations and laws in place that require for certain regulated entities, usually like insurance companies or financial institutions, to notify as well the regulator in a shorter time frame. So, New York Department of Financial Services has a law that says 72 hours. The shortest one is 36 hours under the banking law. So, if you're regulated, I think by like FDIC or OCC. So that's another thing. One of my first questions is like, what business is this? If it's a bank, my radar immediately is going off for all the different options of how they might be regulated, so we don't miss those laws.
Wow. Yeah. So it depends on who you are as a client, basically, or as a company, and what those obligations are. So you mentioned that the SEC has these new rules on cybersecurity, breaching and reporting material incidents. Has there been like strong industry pushback on that? I've read a bit that there's been some lobbying trying to soften what that means. But is that the newest law that you would say is most on point to what you're dealing with? There's been a whole host of new regulations that have passed this summer, the summer of 2023, for those listening in the future.
Yes. So originally, the SEC, they did the proposed rule and then they opened it up for comment. And based on feedback, they did actually change some things. They softened it in some ways. But ultimately, what they came down to was the whole point behind requiring disclosures of material adverse events is to give investors the information they need to make investment decisions. And one of the things that they said if you read all the commentary before the final rule, one of the things they said is you could potentially be giving an unfair advantage to criminals who know that there's a cyber event. But, these other innocent investors have no idea. The challenge, I will say, on that rule is really twofold. One, as much as the SEC says it's not our intent to interfere with an ongoing investigation by requiring these disclosures, so we're obviously not wanting that to be the case. But it feels really strange to be like, we're negotiating with a threat actor, for example. At the same time, we have to put out public notice to the whole world that we're in the middle of negotiating with a threat actor, and you wouldn't be that specific, but people can read between the lines. That just feels strange. And I think that there's real tension between what the law is requiring and how this actually works in practice. And that's where the comments really focused, was on that issue. The SEC is like, yeah, we get it, but too bad. The other piece is, how do you determine what's material? So the SEC has guidance, material adverse events. There's financial issues, reputational, et cetera. I am struggling, candidly, with at what point have you reached that threshold, really? Because if a company has a ransomware attack and they have cyber insurance, then maybe you have short-term financial impact, but if they have enough coverage, even things like business interruption, for example, or a third-party lawsuit should be covered to a certain degree. So it's not necessarily financial. And reputational, maybe having a ransomware attack 3 years ago would have been a big reputational hit, but it's so commonplace now that it doesn't have the same impact. The news story is not as interesting. So that's where I've been digging into this. We're talking to clients, advising them. We're updating incident response plans to account for this. I think you'll probably see over-reporting where companies are going to play it safe and go ahead and put something out because they don't want to be accused of being cute and trying to avoid notification by, making a technical argument, even if the argument I think would be legally and intellectually honest in most cases.
Wow. So it's more of, how are you complying with the law that can end up being more impactful on the back end versus what's actually going on with the breach itself? Like, are you doing any kind of, without going into specific cases, but like maybe in the past you've seen decisions by certain companies to look at a breach and try to disguise it as something that wasn't actually a breach, or candidly not reporting, and that itself could have done more reputational harm than the actual access to the data itself.
Absolutely. So it is difficult sometimes to explain to companies, you had this happen, you have to tell people. And the law requires, in telling people what happened or whatever, that you essentially are making admissions, right? So that if somebody sues you later, like, you can't come back and say this didn't happen. I mean, you can argue, we still had adequate security and happened notwithstanding that, and there are other defenses available. But, it's a weird situation where you have to tell on yourself and then live with the fact that you told on yourself and all the consequences that flow. But I always say, look, people understand at this point breaches happen. I mean, Joe Public gets it. Everyone's gotten a million letters saying, oops, sorry, but your stuff's out there. If you try to bury it and you try to make a decision that you're not going to notify, I always say, when you wake up for the next 2 or 3 years in the middle of the night I say get a glass of water, but I'm going to be honest, it's usually to use the bathroom, right? You wake up in the middle of the night and it's 3 a.m. and you start thinking, it's that thing in the back of your head that's ruminating, that's saying, I'm sure this is going to be fine, but what if? It's that what if. And if your risk tolerance is high and that doesn't actually happen to you, first of all, I'm jealous because this is why I'm a lawyer, right? It's because of that paranoid rumination. But if you're going to think, it's a small chance this blows up in my face, but if it blows up, that could be company ending, because and there are examples publicly out there where that's happened. And companies have tried to treat what was clearly a third-party breach as something that wasn't. And when it came out that was what happened, it can have a huge impact. So you have to be really, really careful. Just, keep your house clean. Do the right thing. Report disclose, show all your stakeholders you're taking this seriously, you will survive. You really will. But what might not be survivable is making the wrong call on not reporting in a situation that clearly requires reporting. I will always say to clients, listen, at the end of the day, I'm not going to judge whatever you do, but I will tell you how a regulator will look at it. Let me tell you how a plaintiff's lawyer is going to frame this in a complaint. And you don't want that.
Yeah, that makes a lot of sense. Listen to your lawyers. Is a good takeaway there.
Great advice, right? Like, I just call a lawyer. Yeah. And look, my favorite people are lawyers. So obviously I'm a big fan. But there are many, many moving parts, and it's increasingly the case that the law and your contracts are going to require you to make some very fast disclosures and decisions. And so that is really where bringing in a lawyer early on is key. Also, just protecting the communications and the investigation under privilege to the extent possible is important. I tell clients, look, the underlying information I can't protect, that's discoverable, but it's the decisions and the discussions we have about what does this mean legally? What are your obligations legally? That's the stuff that, you really want to keep privileged if you can.
Do you think the new slate of data privacy and cybersecurity regulations is really a signal that this area should be more front and center to business decisions, and just in the corporate world that cybersecurity and data privacy, as you're saying, they are different fields, but they are both increasing in importance to businesses?
Yeah, absolutely. I mean, it's interesting because in the United States, we have been ahead of the game on data security issues and requiring disclosures. In Europe, they've been ahead of the game on privacy and really caring about how people's information is used and shared. And now we're starting to see an alignment between, and I say Europe, obviously there are other countries that have, followed the GDPR model, but we're starting to see more leveling out. And so everything, when you think about what a company does, if you're dealing with any kind of human data, touches both security and privacy. You need to keep it safe, but you also need to make sure you're complying with, to the extent you can, the various privacy laws, because A, you have to, and B, it's really about consumer trust and brand and reputational trust. It is a really interesting time to be in this field. I mean, I feel incredibly lucky. I'm also incredibly busy. So the nights and weekends thing is a real thing. But at the end of the day, we're in a time of reckoning, and then layer AI onto that, right? And so, and the technology, both in our ability to help make these laws easier to comply with, and also in our maybe inability to try to figure out how you take this new technology the laws were not designed to address and apply these laws. So, it's like a round peg into a square hole, essentially.
So just one or two more questions here. Can't thank you enough for your time. What advice would you give to somebody who's an aspiring cybersecurity and or data privacy lawyer? But let's focus on the cybersecurity aspect.
Yeah.
What would you say is important for you to have either on the interpersonal and soft skill side, or just from pure knowledge, this is what you need? And why would you advocate for somebody to join this field?
So that's a good question. I think that you have to be very comfortable answering a call at 8:00 at night, spending Labor Day weekends working nonstop on a matter, being on calls constantly. So you can't be too attached to your plans. You've got to be really flexible. I also think the ability to be available is super important. And these are emergency situations. I would consider yourself kind of the equivalent of an ER doctor. So you're on call, it might be that you step out of that party because you have to, deal with a client in a crisis because they really and truly can't wait. So as long as you're comfortable with that concept, I actually don't think you need a technical background. I was a sociology major, which, like, what are you going to do with that other than it's extremely interesting? But I've learned on the job. I've not been afraid to ask questions. And I've stopped prefacing it with this maybe a stupid question. I'll just ask, right? So explain this to me. Or my favorite way of doing this is when the tech guys are kind of going over my head too. I'll say, well, for the non-tech folks on the call, like the client who's, the CEO or the general counsel, can you break that down and tell them or tell us what that means, like in English? And sometimes I know, and sometimes I don't. But, you have to get comfortable with, like, you're the lawyer. You're not going to be expected to know everything on the technical side. That's not your job. But yeah, I think just being really practical in your advice. Anyone can read the law. Anyone can tell a client what the legal obligations are. I think being able to say, and here's where I think companies have gone wrong from a business perspective, that's where you really add value. And I hesitate to say this because someone's going to say, oh, well, it's not really legal advice. It is, though, right? Because it's how to interpret the law and your contractual obligations in a way that meets those obligations and ensures you don't blow up all your relationships and your reputation.
Wow. Yeah. So you don't only need a lawyer to tell you what the law is. You need a lawyer to be wise counsel in that regard. Right. What am I actually doing here? What does it mean to me? And where have you seen other people fail in the past? That's all valuable information. And if it comes with privilege, I still see a benefit. Well, Jena, I can't thank you enough. This has been really interesting for me. I hope our podcast listeners love it. And I can't wait to have another conversation with you in the future.
Yeah, this was fun. Thanks for having me. I really appreciate it.
Thanks for tuning into this episode of the Tech Policy Grind. If you enjoyed the show, get in touch with us at Foundry Podcasts with an S at ilpfoundry.us. or leave us a review wherever you're tuning in. I'm Rima Musa, the host of the show, and this podcast wouldn't be possible without the help of our team at the Internet Law and Policy Foundry. Thank you to Evan Enzer for editing this episode, Lama Mohammed, our social coordinator, Allison McReynolds, our accessibility coordinator, and Tim Lorden at the Internet Education Foundation. See you next time.